Explore this one. The advent of customary law has been groundbreaking, recognizing the rights of traditional commuters, but over time many of its oppressive features and colonial distortions appear to have been exacerbated women's vulnerability. So just how do we marry customary law and social justice? Well, to answer this, we're joined now by the former public protector, Professor Thuli Madonsela. She recently convened a conference on social justice and customary law in her capacity as the Law Trust Chair in Social Justice at the University of Stellenbosch. Prof, it's lovely to have you on. Welcome to the show.
It's a privilege to be on your show, Annika. Thank you for it.
Prof, you say that customary law has become a vehicle of oppression from the advent of the apartheid regime. Can you expand on that for us?
Well, firstly, just not to blame everything on apartheid, Annika. Yes, apartheid may be exacerbated a situation, but the distortions of customary law can be traced to colonialism, and Advocate Ngugai Dobi gave a brilliant paper on where did it all start, with a codification of Zulu customary law by Theophilus Shepstone and denying African people ownership rights by interpreting their law as not allowing anybody to own land or any other movable property. And of course, women were demoted to something less than minority children. So over the years, that was then used by the courts to extend it to every tribe. However, with the advent of the Constitution, we were then required to apply transformative constitutionalism to develop both customary law and the common law to make sure that these were aligned with the Constitution, which includes the constitutional commitment to social justice, human rights, and substantive equality.
I think, Prof, yesterday the Justice Minister, Ronald Lamola, did say that while customary law is recognized by the justice system, it does have to fall in line with the Constitution.
He is absolutely right. The only problem that we pointed out during the conference is that all of us were trained under common law, and therefore we always saw customary law as the only suspicious law, as the only law that had repugnancy in it. And in the conference, we said both customary law and the common law are legitimate laws. Within them, there are aspects that are oppressive, that violate human rights, particularly the rights of women, children, and those people who are not heirs. And therefore, they all have to be aligned with the Constitution. And this we did when we drafted the Constitution. You will see that in Section 30, Section 31, and Section 211 and 212, that there is that constitutional alignment.
Prof. Madonsela, what are the shortfalls, in your view, of customary law?
The key shortfalls of customary law lie in how it has been interpreted in areas such as marriage. As it stands at this stage, and I must take responsibility together with others for this, is the Recognition of Customary Marriages Act doesn't specify exactly at what point is a customary marriage concluded. And this has created huge uncertainties for people. And it's not just people who are married under customary law. Me, you, and anybody else who does business with people who are potentially married under customary law are also affected by that uncertainty, because once you've concluded that somebody's married, even though they thought they were not married, they just paid lobola, suddenly their estate has to be divided accordingly. But for women in particular, they would stay for the rest of their lives thinking that they are married, and suddenly their in-laws, when the husband passes away, come and say you were not married. Or the husband himself decides during divorce that, no, we were never married. So there's uncertainty. Then there's ukutwala, which was a custom that was practiced for various reasons in ancient societies. But these days, it's just used to traffic girls. Relatives that need money out of orphans, they sell their girls in the name of ukutwala. And men really who are predators on young people enter into these kind of transactional relationships in the name of Gutwala. So that's one area. And then there's the issue of just generally succession, inheritance rights, particularly when it comes to land. There are chiefs that think that they own the land, or traditional leaders who think they own the land. And when the man of the house passes on, they then reclaim the land. And there was a case, for example, in KZN where this happened to women. But fortunately, the Ingonyama Trust has been taken to court, and the KZN High Court has at least scored the first goal in favor of true customary law and in favor of rural people by saying that traditional leaders do not own land. They're not trustees in the sense of a normal trustee, and that they have no right to grant leases and expect money from residents.
All right, thank you so much. That's our former public protector, Professor Thuli Madonsela. Thank you, as always, for your insight and time.